Hearing in the appeal, Ravi Balgobin Maharaj against the Cabinet of the Republic of Trinidad and Tobago and another.
My Lords, I lead Mr. Peter Carter, King's Counsel, Mr. Jameh Mohammed Hafiz Beg, and Adam Riley who are members of the UK Bar, and we're instructed by Mr. Vishal Susaran of the Trinidad and Tobago Bar. My learned friend, Mr. Thomas Rowe, King's Counsel, leads Mr. Rishi Das and Ms. Leah Abdullah, who are both of the Trinidad and Tobago Bar, and they're instructed by Charles Russell. May I start by expressing our gratitude and appreciation to the board for dealing with this appeal in such an expeditious manner, in such a short time frame. My Lord, the appeal raises an important point of statutory construction with profound consequences for the democracy of Trinidad and Tobago. The last local government elections, sorry.
Do you beg your pardon?
What's my Lord?
The logo. Thank you very much.
Much obliged, Lord. The last local government elections in Trinidad was held on the 2nd of December 2019, and people would have voted to elect local government representatives for a prescribed fixed 3-year term of office. And it would have been known at that time as part of the social contract that underpins that democratic exercise of voting, that at the end of that triennial period, there would have been the opportunity or the right to vote, we say, to either re-elect the persons whom they wished, or, as the case may be, vote them out, as we say in local parlance. And the idea would have been that Parliament, having for a long time under the County Council Ordinance and the County Council Act, there having been no prescribed time frame for the holding of those elections. In the Municipal Corporations Act, that was changed, and there was in fact a fixed time frame prescribed for the elections, which is 90 days, within 90 days of the end of the term of office for the councillors and aldermen. This appeal concerns the correct interpretation of an amendment, sections 11 and 12 of the Municipal Corporations Act. And I pause to ask the board to take note that these provisions, these amendments, were cherry-picked from a legislative package of local government reform, which was gift-wrapped, promoted, and intended to revolutionize the system of local government that we enjoy in Trinidad and Tobago. There are 3 things that the government says they were able to accomplish by virtue of a one-word amendment. And those 3 things are, firstly, they introduced a new fixed term of office, replacing the old 3-year term of office with a new 4-year term of office. The second is that they extended the term of office for the incumbents by 1 year. And thirdly, that they postponed the local government elections for 1 year. Now, those are 3 very important, distinct concepts with implications for a democracy and very important changes to the 2-tiered system of representative government that we have enjoyed in Trinidad and Tobago for over half a century. The Act, we say, is a carefully calibrated one. And the chronology, the agreed chronology of events would show that the miscellaneous provisions, Local Government Reform Act 2022, it was assented to by the President on the 1st of July 2022, and on the 7th of November 2022, less than a month before the term of office was scheduled to expire, the relevant sections were proclaimed. Now, of course, one doesn't need to think very long and far about how elections are conducted to understand the preparations and all that would go in to an election in the run-up to it. But the point is, it came at the 11th hour, less than a month before the term was scheduled to expire. Now, my Lord, in our written case, we have made the point about...
Does that mean, Mr. Ramlogan, that from what you've told us, elections ought to have been held in September of 2022, is that right?
No, we said the elections would have been due to be held within 90 days thereafter, which would have taken us.
Oh, I beg your pardon.
The 3rd of March of this year.
Correct.
Yeah.
Correct. Now, my lords, the fact that it's plucked out of a package of local government reform and the revolution that it was intended to create in terms of the structural changes to local government, and all of that, we've dealt with it in our written case. I don't intend to detain the board on it. But we do say that there is it is noteworthy and significant that this was cherry-picked at the 11th hour, given presidential assent on the 1st of July, and there's a wait until the 7th of November, less than a month ago, and it is sprung out, the cat is sprung out of the bag. Now, my lords, this matter, when we filed the application for leave to seek judicial review, we were urging that the matter be heard and determined before the term of office had come to an end. Unfortunately, the case management timetable set by the learned judge put us beyond that time, so it was impossible to get the justice that we thought we deserved in the case. As a result, we were forced to then seek interim relief to preserve and protect the status quo, because if we were right, it meant that the councillors and aldermen would have been occupying office illegally and with grave implications, including the expenditure of public funds, the making of bylaws, etc. It was in those circumstances we moved the court for an interim relief, which was refused, and we then appealed to the Court of Appeal. That matter was heard, and after I had completed my submissions in the Court of Appeal in that matter, against the refusal of interim relief, it was agreed by all parties, given a discussion we had with the court, that look, if the appeal were to be allowed or dismissed, we go back before the High Court judge. This is the same judge that set a case management timetable beyond the end of the term, which we were trying to avoid, and then we'll probably end up back before the Court of Appeal, all of which consumes time in a hypersensitive case concerning electoral democratic politics with grave implications. In those circumstances, it was felt that perhaps the Court of Appeal should deal with the substantive underlying issue, given as well the issue of whether there's a serious tribal issue would have in any event engaged the attention of the Court of Appeal. It was in those circumstances the Court of Appeal dealt with the matter, and it dismissed the appeal, but granted conditional leave and final leave, historically perhaps within the space of 48 hours on a weekend. And we are grateful to the board for understanding the urgency of the matter. Now, my lords, before I go any further, there are 3 overarching points I'd like to make. The first is, we accept that it is for a government to proclaim and decide when to proclaim legislation. That is clear, and there is no quarrel with that. That's not the issue, however. The issue is, it having been proclaimed, what is the intention and what is the correct interpretation? And that, we say, is a matter eminently for the court to decide, not, as happened in this case, a government minister who made an announcement as to what the government's policy position in relation to the proclaimed sections were, which is, it accomplishes 3 things. Introduces a new fixed term of office, postpones the local government elections by a year, and also increases, extends the term of the incumbent for a year.
Can I just ask, do we have that announcement
announcement in the papers before us?
Yes, we do. It is in the application, it's recited. As the board may know, the evidence in this matter, we try to keep the record somewhat tight so that the evidence was excluded, but I believe when you look at the application, it would be in the grounds of the application.
Thank you.
In fact, it is at page 9 of the electronic bundle, ground 15. We've set out in paragraph 15 at the electronic bundle, page 9, we've set out the actual quote from the minister. Now, what is of interest when you look at the judgment of the trial judge who dealt with the application for interim relief, you will see in that judgment that the position taken by the minister is that notwithstanding that announcement to the public, they took the position that they had given no directive to local government bodies. And they took the position that it was a matter of personal choice for each and every alderman and councillor to decide how they wish to interpret the amendment and to decide how they should act. So if I interpreted it as meaning that it didn't apply to me as an incumbent, then I can stay in office. And if I interpreted it as meaning that it did apply to me, I should leave office. I mean, that was the state of the evidence. It was the height of arbitrariness, and we did complain bitterly about it in the courts below, in that the logical extension of the announcement was that the government took a hard position that, look, these three things were accomplished by virtue of that one-word amendment. But in the evidence filed, that was the backpedaling that took place, and it led to uncertainty and arbitrariness. As I said, it's in the judgment of Justice Wilson, who refused the application for interim leave in her recitation of the position of the parties. The second point I want to make is that Trinidad and Tobago, as a former British colony, has enjoyed a system, a two-tiered system of representative democratic government for over half a century and even before. Local government elections was perhaps the first taste of democracy that we experienced as a people. It was the prelude to self-determination and self-governance. Before we could have had a direct say in the governance of our own affairs, local government elections was perhaps the democratic prelude that ushered in the change that came with self-determination and self-governance. So local government elections in Trinidad and Tobago, in the historical context of a former colony, is something that we ask the board to bear in mind, and my learned friend, Mr. Peter Carter, will address the board in due course on that history and the importance and significance of it. My lords,
can I ask you, Mr. Balgobin, just for a piece of information?
Sure.
The provisions we're concerned with were brought into force at the time when they were by virtue of the proclamation made by the President
yes.
of Trinidad and Tobago. Now, does the President exercise a discretion as to whether or not to give effect to the wishes of the government?
No.
As to that?
Not on the issue of proclamation. The President acts on the advice of the Cabinet.
Right. Yes, thank you.
Yes. So it is a political decision that is given legal effect by the head of state on the advice of the Cabinet. Now, my lords, this case is novel, and decided cases would be of limited assistance. I say this because when we come to the principles, I ask you to bear in mind that there's a distinction to be drawn between an appointed office and an elected office. What breathes life into an elected office is the democratic exercise and the will of the people. Vox populi, vox Dei. The voice of the people is the voice of God. That is the important umbilical cord in the democratic exercise of the right to vote that creates and breathes life into an elected office. In the case of an appointed office, it's an altogether different kettle of fish, because the executive can make that appointment and the executive can control that. The executive cannot appoint a councillor or alderman. They cannot. They can only be elected by the people. And it is an important distinction we submit. And it is for that reason one has to approach the question of substituting a legislative mandate for a democratic mandate with great care and with great care, because the idea that you can extend a democratically elected representative and you can extend that term of office without reference to the democratic will of the people, that is a very serious matter. And one must bear in mind the ramifications of such a finding. Now, we concede that Parliament has the power to extend the term of an elected office. We concede that, but with an important qualification. We say that Parliament can only extend the term of an elected office holder in exceptional circumstances where there is reasonable justification. For example, as has happened throughout the world during the course of the pandemic, in the case of a war, natural disaster, there must be some reasonable justification that impacts on the right to vote itself, the ability to cast the vote, the ability to hold the elections, that will be proportionate, just and fair, and provide lawful justification to intervene, for Parliament to intervene. But beyond that, we say it's a very serious matter to say that we can substitute a legislative mandate for a democratic mandate without reference to the voice of the people. And with those remarks, as I indicated, my learned friend Mr. Carter will deal with the historical importance and the role of local government. And I want to take you next to three areas of the submissions. One would be the ordinary meaning of the amendments in proper context, the presumption against retrospective application, and the constitutional context and how that is significant and should affect the exercise of interpreting the law. May I start, my lords, just briefly to touch on the way the Court of Appeal treated this issue and ask you to turn to page 324 of the electronic bundle. Page 324, paragraph 76. The Court of Appeal said, "We would nonetheless hesitate to conclude definitively that the principle is inapplicable, save and except where expressly stated or implicit constitutional rights are potentially engaged." This is the principle of legal certainty. Our reservations in this case are born mainly from the fact that we view the scheme of local government as an integral feature of our democracy, even in the absence of a constitutional link. Local government has historically made up one of the tier of our two-tiered system of governance. As long as it continues to exist, the attendant right to vote in these situations can be viewed as nothing less than basic and important. Given this significance, it is difficult to accept that any potential impairment of the right is excluded from a higher level of scrutiny on the sole basis that it does not find expression in the Constitution. So that is the context in which the Court of Appeal, the tone that it set for itself. We say where they fell into error is that the anxious judicial scrutiny, the higher level of anxious judicial scrutiny, simply wasn't brought to bear on this matter. So what do the words mean in their ordinary meaning? Now, my lords, it would be a stretch, we say, an unfair stretch, for the government to say that by virtue of a one-word amendment, you accomplish three major things. One, you introduce a new fixed term of office. Two, you extend the term of the incumbents. And three, you postpone local government elections for a year. All of that is accomplished by virtue of a one-word amendment.
Is that not all accomplished on either construction?
Sorry, my lord?
Is that not all accomplished on either construction? I mean, even if you're right on construction, this only applies to the next lot of local government elected
well, no,
councillors and all.
No,
it still have those three effects in relation to them.
Well, no, you won't, because you won't have a postponement of the elections, certainly, and you won't have an extension of the term of the incumbents. What you will have, if we are correct, is prospectively in the next local government elections, those councillors and aldermen will be elected for a quadrennial term. There'll be a 4-year fixed term prescribed by law, and they will serve that term. There's no postponement of that election. At the end of 4 years, within 90 days, they'll have the elections. And there's no extension to that term because they will be elected for a prescribed 4-year term of office. But on the respondents' interpretation, those three things, you've got to unpack that in the suitcase that is being dragged behind this one-word amendment. Now, can I therefore take you to the Act itself? And I ask you to turn to page 705. At section 11. So we see that councillors, it's 11.1, are to be elected by the electors for each municipality. At one councillor should be returned for each electoral district, and 11.4 says the term of office of councillors shall be 3 years, and they shall retire on the last day of every triennial period, the first of which shall be deemed to have begun on the day on which the councillors were elected to office. Now, I pause there to note the following. The first point is that the first day is immediately linked to the electoral process. So it is the election and the voice of the people through that democratic exercise that breathes life. It is the democratic nexus and umbilical cord that gives birth and life to the elected office and the elected official. Now, subsection 4 should be read in tandem with section 2, subsection 2. So can I just take you to that quickly, which is at page 701. At 701, we have section 2, subsection 2, and it says, references in this act to the day on which the councillors of a corporation were elected to office mean the day or the last day, as the case may be, on which all the returning officers for the electoral districts within the municipality have declared their respective candidates to be elected as councillors. Now, that was done because of, obviously you may have a variation in the dates, but the point is Parliament wanted the start of the term to be the same for all. So the start of the term is clearly fixed. There's one fixed commencement date for the term of office. We go back to section 11 on page 705. And at 4A, it says, an election referred to in subsection 1 shall be held within 3 months of the expiry of the term of office of the mayors, councils, etc. Now, can I pause here to make a small point, which is this. If you extend the term of office, one may argue, because of the way this section is phrased, there may be no need to postpone the elections, perhaps, because if you extend the term of the office, then at the end of the day, the elections must be held within 3 months of the end of the term. And you will see that there are instances where the term was in fact expressly extended by Parliament. In 4B, we are told that notwithstanding 4A, for the purposes only, these are now legislative precedents. And when we say the Act must be read as a whole, the Act must be read as a whole inclusive of these sections. So notwithstanding Section 4A, for the purposes only of the elections due in the year 1995, under this section, such election shall be held within 9 months of the expiry of the terms of office. So here we have Parliament providing expressly for postponement of the election. An express provision, clear and express words, unambiguously postponing the elections.
Did 4A and 4B come in at the same time?
4A and 4B, no, they did not. No, they did not. 4B, 4A and 4B, and 4A. Well, my junior is checking that, so we'll come back to it. But I don't believe that they would have come in at the same time. Yes, 4A came in at 1992, and 4B came in 1995. And then we have 4C, where for the purpose of the elections during 2002, under this section, such election shall be held within 1 year of the expiry of the terms of office. Now, I pause here to make this point. You can postpone local government elections, but that does not necessarily mean that there is an automatic extension of the term of office. It is not a corollary. And the reason I say that is because if I take you to section 273, at page 273, you will see what, sorry? Sorry, page
805.
805, yes, thank you, Jimmy. 805, yes.
I did 4B and C are postponing the election, notwithstanding the expiry of the terms of office.
Yes, yeah. Indeed. So that's why I said these concepts are distinct concepts. It expressly recognizes that the term of office came to an end, and notwithstanding that, because they're cognizant of the 3-month period within which election should be held, and they're extending that 3-month period to a 9-month period for the holding of the election. But my Lord is absolutely correct. There's an implicit recognition that the term of office has come to an end. What is being extended is the period of time within which the election should be held from 3 months to 9 months. At 273, we are told this is when the Act...
I'm sorry, and during that period of interregnum, if you like, presumably the business of local government is carried on by the officials, is it?
The answer is in 273.
Yes.
Right.
273 provides for the continuance of local government.
Yes, it does. So 273, as the marginal note says, it's the extension of term of office of serving members. So 11 deals with the postponement of the elections. 273 deals with the extension of the term of office for serving members. And we have there's a lot of legislative precedents for this. So even when the 13th of September in subsection 1, 1990, is the day the Act was assented to. And even on that day, as a transitional provision, we are told on the 13th of September, 1990, it's hereby extended for a period of 1 year, or to such date as the President may specify by order published in the Gazette, whichever occurs first. Then we are told with effect from the 29th of December 1995, the councils and aldermen whose terms of office expired on the 27th of September shall comprise an advisory committee on the same terms and conditions. So their term of office was not continued as a result of the decision to postpone the elections. Their tenure expired, and what Parliament did is to instead they served as members of an advisory committee. But the point is that term of office came to an end qua councillor and alderman in that capacity. And of course, the detail of these provisions is noteworthy. If you look at subsection 2, it goes so far as to make provisions for deputy chairman of the Sangre Grande Regional Corporation, who should assume chairmanship in the meantime.
Sorry, where are you now?
Sorry, my lord, I am on page 806 at B.
Thank you. Yeah.
And the level of detail continues. You will see at 1B. This is on the 12th term of office expired on the 12th of July 2002. They are deemed to become an advisory committee again on the same terms and conditions. At 1D below, this is for the year 2006. Well, can I just say this to save time? From 2006 to 2009, they did the same thing basically. And to summarize here, the point is this. Whenever Parliament, if we do a chronology and we splice in when they did have elections since the Municipal Corporations Act became law, what you will see is that whenever elections were not held on time, two express things happened. The first is that Parliament expressly postponed the elections when it wanted to, and if it wanted to extend the term of office until the elections could be held, it did so expressly by reference, as we've seen in section 273. So that you would see there might have been several extensions in some cases, but the point is that Parliament specifically addressed its mind to two distinct concepts. One is postponement of the elections, and one is extension of time, or extension of the term of office. And that, we say, is an important legislative precedent in the context of a submission by the respondents that the Act must be read as a whole, inclusive of the proclaimed amendments. We say reading it as a whole includes these important sections. Now, the question is whether Parliament intended for the new term of office, the new fixed term of office, to apply to the incumbents. We say there is absolutely nothing in the language used, nothing that from this conceptual new fixed term of office that lends itself to that retrospective application. And we say that the correct way is for it to be understood as what it is. What it is the introduction of a new fixed term of office. So, I mean, if, for example, if we use the United States as an example, if they amended the law to prescribe, instead of a 4-year term for the President of the United States, and they amended the law to say, well, we will introduce a 5-year term, and without saying that they've extended the term of the incumbent, President Obama as the case may be, without saying that they have postponed the elections, without saying they've extended the term of the incumbent, all they say is they've introduced a new fixed term of office. Would that mean that the incumbent president, the sitting president, gets an extra year? We submit not. We submit how it should be understood and how it should be interpreted is that in the upcoming presidential election, the newly elected president, the people will know that when they go to the polls, they are voting to elect someone for a 5-year term of office, as the case may be, for a new term of office. And that's the problem here. There was no provision to extend the to extend the tenure of the incumbents. Nothing to say it applies to the incumbents. Nothing to say, well, look, we're postponing the elections. And these are very important matters that ought to have been addressed if that was the intention of Parliament, we say. Now, I mean, what if, for example, if we take the respondent's case at its highest, and if by virtue of just a manipulation and substitution of the number for the term for the number of years prescribed. Well, what if Parliament amended the law to introduce a 2-year term of office, and 2.5 years you're elected to serve a 3-year term, and 2.5 years after you're into your term, what if Parliament amended the law to say that it's a 2-year term? On their analysis, you cease to hold office immediately, because the law must be read as saying that when you were elected for a 2-year term of office. So the extra half year you served, I wonder, is it that is now ultra vires, illegal, unconstitutional? But I mean, how would it work? Our submission is that if that were to happen, the incumbents will serve out their 3-year term, that being the mandate that they were given by the people, and that being the term prescribed as at the time they were elected. And in the new election, whoever is elected will serve a 2-year term of office. And we say that, as a matter of logic and common sense, it's the right way to interpret it. One has to bear in mind, this is not a commercial case. These are not private law rights. This is a serious constitutional case raising serious public law rights. And the law must not be so esoteric and obscure so that the man in the street would not understand an important matter such as this, governing his right to vote and his right to democratic participation. And that is why we say, in the simple, clear language, what it means is prospective and not retrospective. I mean, what if, for example, as obtained before Section 11, what if you had appointments with no end date, so that they were appointed to serve and there's no fixed time for holding the election? And what if they then introduced a 3-year term? Would it mean that the incumbents, when that provision is proclaimed, that the incumbents get 3 years extra? Or does it not apply prospectively to incoming persons who will be elected by the public in the knowledge that they're electing them for this new fixed term of office? Now, and of course, to make matters even clearer, what if Parliament had proclaimed this amendment during the period of the interregnum, to use the language of my Lord President? What if they proclaimed it during the interregnum? So 3 years have come to an end. But between that time and when the election is held, they proclaim this provision. On my learned friend's analysis, well, then the law must be read as if they were elected to serve a 4-year term. So that if they were elected to serve a 4-year term by retrospective application, then even though their 3 years have come to an end, is it that they become automatically reinstated by operation of law?
Well, I'm wondering if that's right. But it may be there's actually a more powerful point made for you if it's not right. I mean, the Act was passed. It got presidential assent in July, the 1st of July. Now, if the provisions are read as being capable of applying to incumbent councillors, then the consequence is to enable the government to determine, through the timing of the proclamation, whether or not the incumbent councillors benefit from an extra year. I mean, my impression would be that if a term had actually expired, then they're functus, and they couldn't be, as it were, brought back to life again by the proclamation. And so whether they benefit from an additional year would depend on whether the government sought the proclamation in, say, November, as they did, or later in December, after the period of office had expired.
Yes, and you see, the danger in that is this. You, in effect, place in the hands of the executive, rather than the legislature, the power to postpone the elections, extend the term of the incumbents, and introduce and prescribe a new fixed term of office. But my Lord is absolutely correct that the possibility of manipulation is there, and it is one that can be easily used to the detriment of the public interest. Look, my Lord, if you look at the application, in the factual matrix that is set out in the application, we've cited extensively as to what the reaction in Trinidad and Tobago was to this measure. You will see the leading newspaper, the Daily Express editorial. You will see leading leaders from civil society. But the long and short about it is, it came like a thief in the night.
So you're accepting the President's point that if the 2022 Act had been proclaimed after December 2022, then the councillors wouldn't be reinstated. Their term had expired, and the Act could only apply prospectively. But if as was done, the Act was proclaimed before the expiry of the term, then, as the President says, the government was given the decision whether or not, on the government's interpretation, whether or not to extend the term of office of the current government.
But from one perspective on the government's interpretation, because the other perspective on the government's interpretation is this: if the law is meant to be retroactively interpreted, such that you are in effect rewriting history, as it were, and that is to say, you read the law as is. If someone, as they say, if someone wants to see what's the term of office for which the councillors and aldermen were elected, you go to the Act and you see 4 years. So you go retroactively and you say, well, look, when they were elected to serve a 4-year term of office. Now, when you view it from that perspective, which is also their submission, when you view it from that perspective, well, whether or not the term of office came to an end on the old law or not, perhaps they might also be reinstated, as it were. It depends on which perspective one applies. But either way, the point is that it's problematic and it's wrong.
I suppose one could link this to the point you were making earlier, that the point being made now is that on the government's interpretation there is scope for what you have described as manipulation and by the government, and because that's constitutionally undesirable, one might hesitate to construe the provisions in a sense which had that effect. And then you can point to the way in which these matters have been dealt with in the past, in 1995 and 2002, as we've seen, as supporting the view that the constitutional tradition in Trinidad has been for Parliament to deal with these matters itself, rather than conferring a discretionary power on the government.
Indeed, my Lord. And we say that the way Parliament dealt with it is conducive to the maintenance and upholding of the rule of law in a democratic society.
But Mr. Ramlogan, is not your construction vulnerable to the same sort of problem? Suppose the amendments have the effect for which you contend, which, put it shortly, is that they don't apply to anyone who is in office, and they only apply to newly appointed persons once they have, after proclamation, been elected. Why is there not scope for government to decide whether or not it wants to extend the prospective next lot of local government officers by proclaiming before or after the election, which would otherwise have taken place by the end of this March?
Well, my Lord, the idea is this: if the government proclaims an amendment to introduce a new fixed term of office, our position is that once the people know that when they go to the polls that they are electing representatives for a 4-year term of office, then that is fine. The people must know that they are what they are voting. It's an important term of the social contract, if I may use that analogy. But it's an important thing for people to know. And if before
people need to know, don't they, during the election campaign, not just on the day they go into the polling booth.
Well, yes. Yeah.
Otherwise, it distorts the way in which the election, those promoting particular candidates may promote their candidates.
Yes, my Lord, what we say is if the amendment takes place before the election, it's fine in that you know that you're prospectively going to vote for people for a fixed 4-year term. If, however, the amendment comes after, then it will not apply to the incumbents. It will apply prospectively henceforth to the next election.
So while there is scope for manipulation there in the sense that the government can postpone the shift from 3 to 4-year terms, you would say there is at least no underhand dealing in the sense that people haven't been elected by the electorate for 3 years and then find themselves serving 4.
Of course.
Yeah.
Yes. That's correct. Bear in mind, the government will not know. It's one thing for you to know the political configuration of the local government bodies and then exercise a power manipulatively to protect and preserve that status quo. So, for example, if I know that I control the vast majority of government bodies, but, at midterm or whenever I feel I don't want to face the polls, I can then exercise powers accordingly. But it's a lot fairer and more transparent to say that, look, if you go to the polls and you know there's a prescribed term, whether it's 4 years or 3 years, that people elect people on that basis, it's fairer and more palatable, quite frankly. So we say there is really there is no textual warrant or justification for saying, in the face of these legislative precedents, for saying that this amendment shall apply to the incumbents, rather than simply saying that it should apply prospectively. And these are matters that would have required express and clear language. Now, my Lord, the principle of legal certainty, the respondents take issue with us on that and say, well, look, it's a question of whether it should only be confined to cases which involve constitutional and fundamental human rights and so forth. Well, look, in this type of case, where the right to vote is engaged, we say that principle, whether you view it as an analog to that principle or whether it's the same principle, the short point is we say clear and express words are required so that there is no uncertainty about the matter. Yeah. So, my Lords, can I, on that point, take you to the case of Lawfus Sheriffien, and we will find that at I'll take you to page 1189.
Sorry, page?
Page 1189.
Right.
And at 1189, Lord Muster, speaking for the House of Lords, said at the letter E, he said, "My Lords, I must begin with an argument which, in the opinion of the arbitrator, provided a short answer to the problem. As I see it, as from January 1992, I am bound to read the Arbitration Act 1950 as if Section 13A was incorporated into it. That, as it seems to me, is the clearest possible indication that the legislation has retrospective effect. It requires a tribunal from January 1992 to proceed on the basis that the power has been there since 1950. The position is so clear that I do not need to analyze numerous cases cited in the submissions." And then he says, "This approach has an attractive simplicity, but I cannot accept it." And that's the same, and we say that's on all square fours with the position taken by the respondents. They say, look, the answer is simple. Read the law and see what it says. It's been incorporated. It's now 4 years. It's been incorporated into the law, and that's the end of the matter. At the bottom of the page, letter H, he says, if the addition of Section 13A were fully retrospective in the sense proposed by the arbitrator, it would follow that there has been since 1950 a power to dismiss an arbitral claim for want of prosecution, although no such power was recognized to exist in the High Court until 18 years later. It would also follow that if in, for example, 1986, an arbitrator in ignorance of Crawford had made an award purporting to dismiss a claim for want of prosecution, the award would have been wholly ineffective. Yet, if the effect of the Act was to write back Section 13A powers to the year 1950, the parties would discover years later that the arbitrator was retrospectively vested with powers which he had wrongly asserted, with the consequence that the arbitration would be deemed with effect from 1st of January 1992 to have been brought to an end in 1986. I mean, that's the problem with, viewing, that's the problem about saying, well, look, they were elected for you must read the law as though they were elected for a 4-year term. And that's the simple answer to the challenging issues we raise about the correct interpretation in this matter. At the bottom of page 1190, it says, my lords, it would be impossible now to doubt that the court is required to approach questions of statutory interpretation with a disposition, and in some cases a very strong disposition, to assume that a statute is not intended to have retrospective effect. Nor indeed would I wish to cast any doubt on the validity of this approach, for it ensures that the courts are constantly on the alert for the kind of unfairness which is to be found, for example, in the characterization as criminal of past conduct, which was lawful when it took place, or in alterations to antecedent national, civil, or family status of individuals. Nevertheless, I must own up to the reservations about the reliability of generalized presumptions and maxims when engaged in the task of finding out what Parliament intended by a particular form of words, for they too readily confine a court to a perspective which treats all statutes and all situations to which they apply as if they were the same. This is misleading, for the basis of the rule is no more than simple fairness, which ought to be the basis of every legal rule. He says this lower down, he says in the same paragraph, it's no more than common sense, the application of which may be impeded rather than helped by recourse to formulae which do not adapt themselves to individual circumstances and which tend themselves to become the subject of minute analysis, whereas what ought to be analyzed is the statute itself. At letter E, he cites Lord Justice Stoughton from the Tunnicliffe case, where it said, in my judgment, the true principle is that Parliament is presumed not to have altered the law applicable to past events and transactions in a manner that is unfair to those concerned in them. It is not simply a question of classifying an enactment as retrospective or not retrospective. Rather, it may well be a matter of degree. The greater the unfairness, the more it is expected that Parliament will make it clear if it is intended. Precisely how the question of unfairness will be answered in respect of a particular statute will depend on the interaction of many different factors. It will vary from case to case. Thus, the degree which the statute has retrospective effect is not constant, nor is the value of the rights which the statute affects, or the extent to which the value is diminished or extinguished by the retrospective effect of the statute. Again, the unfairness of adversely affecting the rights, and hence the degree of unlikelihood that this is what Parliament intended, would vary from case to case. All these factors must be weighed together to provide a direct answer to the question whether the consequences of reading the statute with the suggested degree of retrospectivity are so unfair that the words used by Parliament cannot have been intended to mean what they appear to say. Now, my lords, in the ensuing pages, one of the important criteria to which the court said we should have regard is the nature of the right. As he speaks about the value of the right, we say the nature of the right and the value of the right in this case is of the highest and most sacred of rights.
Is it your submission that the whole of the package of amendments to the MCA were intended to come into force together?
Oh, my Lord,
Or was it permissible for the minister to introduce them component by component or element by element?
Oh, my Lord, on a strict legal analysis, the power to proclaim amendments in a piecemeal fashion does exist. But what we do say is that when one has regard to the revolutionary changes in the package of legislation, which seeks to introduce an entirely new system of local government altogether, we say that there is no good reason why the change should not be interpreted prospectively, so that the elections could and should have taken place, and those who are elected will serve for a 4-year term. There is no evidence in this case, for example, to suggest that they needed this 4-year term to apply to the incumbents as a prelude or prerequisite to the reform process.
So I beg your pardon. So you don't go so far as to submit that all of the amendments to the MCA set out in Section 3 of the Amending Act have to be implemented together?
No, I can't say that on a strict legal analysis, because the power to have a proclamation on a piecemeal basis in law exists. What I do say, however, is that it is important context to understand the intention of Parliament and the correct interpretation of the amendment, to understand that this is part of a package of local government reform.
And so if we look, for example, at page 603 of the electronic bundle, where the amendments to Section 11 are set out.
Yes?
As I understand your submission, those do not have to be introduced as part of a package with the other proposed amendments to the whole MCA scheme.
No, not necessarily.
But there is nevertheless some sort of implied prohibition against their introduction at any time other than during the interregnum. Is that right? In other words, they apply only to newly elected councillors and aldermen, whether we're dealing with Section 11 or Section 12, on respectively page 603, 605. Those amendments can only be introduced after the term of those presently serving aldermen and councillors has come to an end, but before those new prospective councillors and aldermen have been elected.
No, my Lord, we don't say that.
I beg your pardon. Then, I've misunderstood you. Do these two? Do we read the Act then as, once amended, as containing two parallel sets of provisions? One which applies to presently serving aldermen and councillors, and one which will apply prospectively to newly elected councillors and aldermen?
Well, my Lord, what we say is this. The change from 3 to 4 to introduce a new prescribed fixed term of office, we say that change, without more, cannot mean that it operates in law to extend the term of the incumbents, and postpones the election without any provision that specifically addresses those two issues. That is our submission.
If this amendment is made as it was, then which is the provision which continues to apply to the presently serving aldermen and councillors?
Well, it would be the provision that says that they were elected for a 3-year term of office, and the election should be held within 90 days. I think
so. That sits in a sense in parallel with the amended Act, which only applies to the newly elected aldermen and councillors.
Yes.
Is that the way it works?
Yes.
We sort of notionally have.
Yeah.
We read it as impliedly containing two different terms, one applying to the presently serving councillors and aldermen, and one which will apply to those who are elected after the next set of elections?
Well, what we say is this, my lord. When you elect people and there is a prescribed fixed term of office, that you elect them for that prescribed term of office. And if you introduce a new fixed term of office after the elections, that can only apply and should only apply to the new elections prospectively and those who may be elected at that time. But if you wish to know what is the term of office for which the incumbents were elected, you have to read the law as it stood at that time, which is that they were elected for a prescribed fixed term of office for 3 years, with elections to be held within 90 days at the expiration of that term. So that we see no, in other words, we see no inconsistency, and it's not necessarily that there is an incongruous parallel, as it were. It is just simply, my lord, that at the time you exercise your right to vote, one of the critical ingredients that you must know out of fairness in the exercise of that democratic exercise must surely be, well, you know, what's the term of office that in respect of which I'm electing these persons? Because that may have a bearing on how you choose to exercise your right to vote, as the case may be.
Yeah.
But, my lord, there is no incongruity as such. And what we say is that Parliament not having provided that, look, the new term of office shall apply to the incumbents, or that the term of office for the incumbents is hereby consequentially extended for a year. In the absence of that, given the legislative precedents, we say that there is no textual warrant or justification for applying the new fixed term of office that is prescribed retrospectively, my lord.
Yes, thank you very much.
I'm much obliged, my lord. So, my lord, on the case of the office, what Lord must have stressed amongst the criteria that should be applied is, one, the nature of the right, the value, the nature of the right, the value of the right, and the context. Now, these cases all involve private law rights, but we say that the level of judicial scrutiny and the level of clarity that is required in the case of a hypersensitive democratic provision like this should be all the more clearer. Even greater clarity is needed, because you couldn't ask for more homage to be paid to the principle of certainty and the principle of predictability and regularity in the conduct of elections and the term of elected office when it comes to elections as opposed to anything else. Now, my lords, my learned friends pray in aid, section 29(2)A of the Interpretation Act, which we'll find at page 554. And we say it is not relevant for two reasons. If you look at section 29(2), it says where a written law repeals or revokes a written law in this subsection called the old law, and substitute another written law, therefore, by way of amendments, revision, or consolidation, all officers or persons acting under the old law shall continue to act as if appointed under the written law so substituted. And our simple position is, look, there's been no repeal and reenactment, as it were. And we say further, this section, Parliament was careful to confine it to persons who were appointed rather than elected. So it doesn't assist us.
So, I mean, why do you say there's no repeal?
Well,
there's an amendment removing one provision and replacing a provision.
Well, fair enough, my lord. But the way we interpret it is, it seems to suggest that it might have been. It might have been intended to speak to a wholesale repeal and replacement of the written law rather than part. But, my lord, in any event, the more compelling answer, really, my lord, is that it doesn't apply to elected office. It clearly does applies to appointed office. holders.
Yes, because it does speak in subsection 2 of substituting another written law by way of amendment. But your point is 2A refers to appointment rather than election.
Indeed, my Lord.
Yes, thank you.
Much obliged. Now, my Lord, we next, my learned friends also say in their case that, look, the past amendments all deal with the postponement of specific elections, where it was thought desirable specifically to extend certain terms of office. And they say none of the provisions deal with a situation where the term of office was being adjusted not just for the present office holders, but generally. We say that misses the mark with respect. We accept that the amendments are sufficiently clear to replace the 3-year term with a 4-year term for all future councillors and aldermen who may be elected, but we say that there is no sufficient clarity to extend the term of sitting councillors and aldermen. And had that been the intention of Parliament, it would have used the very clear and specific language as it did many times in the past. They also say, well, the fact that there may be other ways of or other formulations that could have been used by Parliament is not an answer to their interpretation. And what we say is that in the context of a piece of legislation where Parliament did, in fact, have a formulation in clear and express language which it devised in the past to address precisely these issues, we say that it is clear that if Parliament wanted to repeat that they would have used similar language and similar provisions.
Yes, because I suppose you're saying that even if this was being done generally for the future, if it were to apply to incumbents, they could have said, for the purposes of the 2022 election, incumbent councillors will serve an additional year. Correct. And they didn't say that.
No, they didn't. I mean, Lord, you see, the short point is, if Parliament postpones the election, it is not automatic that the term of office of the incumbents will be extended. You could, for example, the term will come to an end and they'll be appointed as the body of advisors, or, as you will see from section, I think, 253, what will happen is that the mayor, in tandem with the CEO, there's a committee in place that operates during the 90-day period when the term of office comes to an end, and they will continue to run the corporation. Is it 253? Yeah. So I'll come to that provision. My little friend cite the example of the Welsh example, and can I just take you quickly to that at page 593 to show you why we say it doesn't really help their case with respect. In 593, we have the Local Government Act firstly, and what I actually noted at section 26 firstly is that the ordinary elections of councillors and new principal councillors shall take place in 2017 and every 4th year after 2017. The term of office shall be 4 years. On the 4th day after such ordinary election, persons who are councillors shall immediately before the election shall retire, and the newly elected councillors shall assume office. Now, first important distinction, 26.3 is different because the law expressly provides that in the case of Wales, they retain their office until 4 days after the election. That's not what happens in Trinidad. The law provides the reverse. Your term of office comes to an end at the end of the triennial period, and the election has to be held within 90 days. In other words, the seats are vacant. The seats are vacated prior to the holding of the election. And the only person who retains their seat is the mayor or the chairman of the corporation, because there's a specific provision for that. Because during the period of the interregnum, which is the 90-day period, or as Parliament extends it in some cases to more than 90 days, during that period, what happens is there's a committee chaired by the mayor or the chairman, and together with the CEO, they run the corporation. It doesn't grind to a halt. And then, if I take you and ask you next to turn to page 5 88. One has only to look at the title of the order. It says the local authorities change to the years of ordinary elections. This is the kind of simplicity and clarity, even in the nomenclature, that one would require for the postponement of an election or the changing of the term, as it were. At section 3 on page 589, the years in which the ordinary elections of councillors of local authorities specified in Article 2 are to be held are changed, replacing 2017 to 2022. So there's a clear postponement of the election. Section 4 on page 490. The term of office of existing councillors under 26(2) and 35A is accordingly extended by 1 year. Now, I pause here. There was no need, perhaps, to have this extra provision inserted, because we know that they hold office until 4 days after the election. So if you postpone the election, it stands to reason that the term of office will be extended until 4 days after the election. But notwithstanding that, there is a clear and express provision to speak to the incumbents, to extend the term of office. That is to avoid any uncertainty, given what is at stake and the value of the rights that would be implicated in this matter. And then at the bottom of the page, you have, at the bottom of 590, explanatory note, and this is important. It says the Welsh ministers may, under Section 87 of the Local Government Act 2000, make provision by order to change the years in which the ordinary elections of councillors and of any specified local government authority are to be held, so that there is express provision in the Parent Act for by order for there to be a change in the years in which the elections can be held. There is no corresponding provision in the Municipal Corporation Act of Trinidad. And then the explanatory note continues that tells us Article 3 and Article 4. It's clear that there was a deliberate amendment to provide for the extension of the current term of office. Yes, and then, and at page 3341, in the supplementary bundle, page 3341, if I may just switch into the supplementary bundle, page 3341.
77.
Oh, sorry, what page?
Electronically.
77, sorry. Yeah, 77 of the PDF. At section 87, it's a page 77. You will also see that, and 87.3.
Sorry, I'm awfully sorry. Which page?
This is a supplemental bundle, yes. And it's page 77.
77, thank you.
And at 87, section 87.3 says, an order may include provision to secure the retirement of existing councillors at times different from those at which they would otherwise retire. So the legislative scheme is quite different, we see. And my learned friend pounces on the word accordingly and says, well, look, accordingly there simply means that, well, look, it is a corollary, and as night follows day, if you postpone the elections, it means that as a corollary of that is that the term of office must be automatically extended. And we say that might be the case in the way, given the provisions in the Welsh legislation, but certainly not in Trinidad and Tobago, because as the legislation has shown us, postponement of elections did not equate to an extension of the term of the incumbents, because there are many options that one can utilize in dealing with that.
I wonder if you can take anything from if one looks at section 11 of the Municipal Corporations Act, which is in its unamended form at page 705.
705 minutes?
705.
Yep.
It's all framed in the future tense. Councillors shall be elected. The number of councillors shall be. The councillor shall be returned. The term of office of councillors shall be.
Yes.
And so on.
It's
So it is a prospectively
correct.
look. It's a forward-looking provision, or these are forward-looking provisions.
Yeah, and it's got to be, because one is dealing with elections at the end of a prescribed term of office. And the point is that that's why we say that it is conducive to a prospective interpretation, because it is forward-looking towards the newly elected members and the term of office that they will have to serve, as opposed to looking in the rearview mirror to say that those who were elected for a 3-year term shall now somehow magically be serving a 4-year term without any provision to authorize that. I mean, in other words, you can't really go back in the past and rewrite history to say those who were elected for a 3-year term should now be treated as though they were elected for a 4-year term, when there is no words in the amendment or in the Act to authorize such an interpretation.
Yes. There is still the problem that Lord Kitchen raised, that if you look, for example, at subsection 4...
Subsection 4 of?
At subsection 4, when the proclamation was made in November, the result was that subsection 4, from that point onwards, read, the term of office of councillors shall be 4 years, and they shall retire together on the last day of every quadrennial period. And so you have to find a way of, well, you've presented an argument. The challenge for this interpretation is to find a way of saying that subsection 4, as amended, doesn't apply to the incumbent councillors.
Yes, the short answer to that as well is that when Parliament intended for there to be an extension to the term of office of the incumbents, it did so by express provision and clear language. It did not leave it to a matter of implication or inference, because it's far too important a matter to say that it's an inferential or deductive exercise. I mean, ordinarily speaking, there would be a transitional provision. As we saw when the Municipal Corporations Act came into existence, they created a transitional provision so that there's a legislative bridge to address that gap.
I mean, effectively, you read 4 as if the words "to be elected" were there, as they are in...
Yes.
Effectively in substance in 1 and also expressly in 2.
You'd have to read it into 4A and 4B as well, I think, wouldn't you?
Yeah.
To make it...
Indeed.
So you read 4 as the term of office of councillors to be elected shall be 3 years. And what about 4A and 4B? I mean, we don't need to worry about 4B because that's historical. Is there any problem with 4A?
The last term of office of the mayor comprising...
No, it's still a 3 months.
If you alter 4, 4A will follow.
Yeah. Yeah.
I understood the point on the tenses would be that the term of office of councillors, you say, shall be 4 years. It's not is 4 years.
Yeah.
Yes. Correct.
Yes.
The Interpretation Act on page 647 actually does contemplate the meaning to be given to a provision which is expressed in the present tense. So page 547, section 10. introduces the always speaking approach to interpretation and refers to anything expressed in the present tense. So that's addressed there, but as my Lord has pointed out, shall be is not at any rate obviously the present tense.
Correct.
Yeah.
You see, my lords, one has to also adopt a common sense approach to this exercise. And what I respectfully submit is this. When you elect representatives, there must be a certain framework within which that election takes place. And one of the boundaries, one of the lines of demarcation that one would look to for that framework would be the term of office. And as a matter of pure common sense, once you've voted in the knowledge that you will be electing people for a prescribed term of office, which ought properly, in the interest of fairness, to be known beforehand, then when one looks at it from that perspective, we say that it would be unfair to say that that's a shifting goalpost without any reasonable justification. I mean, it's subject to reasonable justification, as we say in the case of a pandemic and so forth. But otherwise, no. In fact, my lords, we did provide a table where we did a sort of a review, an overview of when elections were postponed and when terms were extended. And what page is that?
And are you saying that if Parliament had in turns provided for an extension of the office of the elected representatives here, that could still be held to be invalid because it wasn't reasonable or proportionate?
It would depend perhaps on the reason advanced. I mean,
well, so the Act would contain no reason at all. It would simply say, in very clear terms, similar to the terms used in Section 273, that the terms of office are extended by a year. Are you saying that could still be held to be invalid or inapplicable in some way on grounds of unreasonableness?
Well, my Lord, it's not necessary for us to decide that, to address that here, but what I do say is, insofar as context and the history to the amendment may be relevant to the interpretation exercise, it may inform, in an appropriate case, it might inform and provide guidance to the correct interpretation. I go no further.
Thank you.
Much obliged. Now, my lords, if I may, yes. So what we say, my lord, is the rights that are affected is, one, we say there is a right to vote which is affected because the postponement of the elections amounts to a frustration of that right because you've taken away that right for a year. And also in terms of the sitting councillors and aldermen, they would have signed up for a 3-year term of office. There is evidence as to the fact that some of them may not really want and have planned their lives with the intent that they would serve beyond that 3-year term or even offer themselves for re-election. And the idea is that the Act prescribes that there'll be a $4,000 fine if they resign, except on 2 limited exceptions which are not relevant to this case. Now, my lords, in the supplemental bundle, we have put a case from the Turks and Caicos, which is the CMK BWI Limited versus the Attorney General of Turks and Caicos, where the principle of fairness, which was applied by Lord Mustill in the Leoffice case, was given cited with express approval, and that is a judgment of this board, delivered on the 3rd of November 2022. Insofar as there is...
Could you refer us to the page number?
I certainly can, my Lord. It's page 84. And the relevant page would be page 100. Paragraphs 28 to 30. And then, of course, can I take you to McQuillan's...
one moment.
Sorry. Page 101 of the supplemental bundle.
And is it
Paragraphs 28 to 30. A recent judgment of the board where they've cited with approval the reasoning in the case of the office Sherifian.
Yes, this is all in the context of retrospectivity.
Indeed, my Lord. And the fact that the underlying principle of fairness would apply. And then at page, in the supplemental bundle as well, at page 171, there's a very important, there are two paragraphs that are pretty important. That is paragraph 151 and paragraph 153, where they discuss the fact that the presumption against retrospectivity reflects the values of fairness at paragraph 151 on page 171, reflects values of fairness, legal certainty, and the rule of law, because it is desirable that people, including public officials and public authorities, should be able to determine their legal rights and obligations at the time of acting or committing or omitting to act. It is generally unfair to treat people as subject to obligations of which they were not on notice at the material time. And then at paragraph 153, they do a very good survey of what was said by the various judges in the case of Wilson versus First County Trust, and I can just simply ask my lords to read that in paragraph 153. Now, my lords, in the limited time that I have left, I'd just like to touch on the constitutional aspect of the case. What we say is... Sorry,
I just wanted to ask you, the Section 11 tells us that the councillors all retire together on the last day of a triennial period, or now quadrennial period. Is it possible for a councillor to retire early?
Yes, because there are two exceptions. You can retire on the ground of ill health, or you can retire if you have moved residence and it becomes onerous for you to perform your duties in the particular municipality.
But if you don't meet either of those conditions, if you remain in good health and you haven't moved, then on the government's approach, you've effectively committed yourself to a period of service, a public service of 3 years, and you then have it increased to a period of 4 years, and there's nothing you can do about that.
Precisely.
Right.
Well, you can retire, but you have to pay a fine.
Correct.
Yes.
Correct.
Yes.
Yes. And again, when you signed on to serve in elected office, you would not have signed on. That is altering the nature of your rights and obligations, as the case may be, because that is a significant shifting of the goalposts.
Is there a statutory age limit for service in either of these offices?
No.
What's the provision that requires the payment of a fine?
1 second.
I think you probably gave it to us, but I've...
Section 22, 25.
And I think it's being increased to 10,000.
Yes, that's correct. It's another reason why the reforms are so important. Indeed, my lord, it's been increased significantly. It's more than doubled.
Has that been brought into force?
No, thankfully not as yet. So it's sections 25 and 22. Those are the relevant provisions. Now, my lords, on the constitutional implications, we say this. When Trinidad, there are two ways to view the right to vote in the constitutional paradigm, and one is with a capital C and the other is with a common C. In the capitals, we say firstly that it is constitutional in the sense that the word was used by Lord Bingham and others in the Watkins case, that the right to vote is just so sacred and fundamental. It's so obvious that it doesn't need justifying that it is a sacred and fundamental and extremely important right. I mean, the board had said in the Coriati case that the right to self-determination, to elect those who govern you, is perhaps the quintessence of a democracy. It is a cardinal principle of a democratic society. And for that reason, we say that when Trinidad and Tobago, it's a unique constitution in this respect, my lords. We have a generic right to freedom of expression. But when the Constitution Conference was held at Marlborough House, the leaders at the time negotiated at the Pact for Independence the inclusion of a separate and discrete right in addition to the general right to freedom of expression, which you will find in constitutions the world over. In addition to that right, Trinidad and Tobago introduced a right to freedom of political expression. One may argue that could have been easily a subset that is subsumed in the generic right to freedom of expression. But the forefathers of our Constitution placed on a separate, independent footing the right to freedom of political expression. The Court of Appeal in this matter has held, and there is no cross-appeal against that finding, that that right to freedom of political expression includes the right to vote, which is the ultimate form and manifestation of political expression. It is perhaps one of the more tangible ways to articulate your political preference and expression. And if that be the case, we say, at the time the Constitution came into being, this board has already held that the rights which were codified and entrenched in sections 4 and 5 as fundamental human rights, were rights that were already in existence, and our citizens were already enjoying those rights. So it declared rights that were already in existence. Well, what right to vote was in existence at the material time? We had a two-tiered system of representative government, and there were two rights to vote: the right to vote in general elections and the right to vote in local government elections. And therefore, insofar as the Court of Appeal has accepted, and the respondents have accepted, that that right to freedom of political expression gives constitutional protection to the right to vote, but they seek to limit it to the right to vote in general elections, we say that there is no justification for that. We say that the right to vote in local government elections is of equal importance, and if it is not of equal importance, it is in the wrong just beneath the right to vote in general elections. And we say that that right to freedom of political expression would have given constitutional recognition and shelter to the right to vote in both local and general elections. And we say that as a result of that, the constitutional implication is such that it reinforces and underscores the need for clear language to displace that right. Because the right to vote has a temporal component in this case. And it was a right to vote in an election to be held within 90 days at the end of the triennial period. It is defined by legislation. It is not an abstract right to vote. It is not in abeyance. It is a right to vote in an election to be held within 90 days of the end of term. And we say that insofar as the right to vote is with a common C constitutional because of its fundamental importance, or capital C constitutional because it has been given constitutional recognition, protection, and shelter, we say on either basis, without having to go the extra mile, we say that it is something that would have justified and warranted the use of clear and express words to say that we are postponing elections for the entire population of Trinidad in local government elections, and that the term of the incumbents would be is hereby being extended. So, my lords, we said that is another reason why it is so important. So, my lords, we are, of course, aware of the case of Mohan, of the judgment of Mohan. My Lord Hodge was, of course, gave the lead judgment in that matter. And briefly, I'll say the following. Mohan is distinguishable because it concerned the disqualification of prisoners voting in a referendum. It was not a case that concerned the election of a representative. Local government elections are very important. In fact, some people choose to vote in local government elections, but not in general elections, because it is the local government representative that attends to your personal and direct needs. A referendum does not elect a representative. The second point is that this Article 3 of the first protocol to the Convention for the Protection of Human Rights and Fundamental Freedoms is quite clear. It deals with parliamentary elections, as Lady Hale said in her judgment. It deals with, in the choice, the words used are in the choice of the legislature. Legislature, we accept, it's obvious, does not include local government in the context of that particular protocol. But there is no textual warrant for introducing that limitation on the right to freedom, on the constitutional right to freedom of political expression, which we know from all the authorities from this board must be interpreted in a generous and wide manner. So, in other words, it doesn't say a right to freedom of political expression insofar as you elect someone to serve in the legislature. So it's two completely different provisions, and of course the Constitution in Trinidad is the supreme law. This case is about Section 4E, and we say it is completely different. We are not relying also on a common law right to vote, which was the issue that attracted a lot of intellectual analysis in the Mohan case. We are relying on a statutory right to vote, which is based on the Municipal Corporations Act, and complemented by Section 4E. And we also say, for good measure, that Lord Kerr's dissent, when he spoke about the modern trend towards promoting what he called effective political democracy, is perhaps more opposite in the case before the board, which deals with the right to freedom of political expression in the context of a country whose constitution, in the preamble, affirmed our belief in a democratic society, and where Section 2 proclaims that it's a sovereign democratic state. My Lord, unless there are any questions, I think I would like to yield to my learned friend, Mr. Peter Carter, who has kindly agreed to address the board on the historical importance and relevance of the local government elections, unless there are any questions from me.
Could I just ask this? I just want to clarify, if I may, what you're saying about Article 4 of the Constitution.
Yes, please.
Now, I understand the point made that the provisions of the Constitution emphasise the importance of democratic participation. Yes. I fully understand that. What I'm a little unclear about at the moment is whether you're saying that the provisions with which we're concerned constitute a breach of the rights conferred by Article 4 or confirmed. Because if they do, presumably you're saying that the relevant act should have been passed by the relevant supermajority. And so
what we say is this, Lord. The interpretation contended for by the respondents deprives the public of the right to vote, which would have crystallized when they voted for the incumbents.
Yeah, I follow that, but
yes,
it's more the point of linking it to the Constitution.
Yes,
the short answer is you say yes, that it is a breach of Article 4. So it's an amendment which required to be passed by the relevant supermajority.
Yes, we said that they did. We said that the interpretation contended advanced by the respondents runs headlong into that brick wall, that constitutional brick wall. And that's why, but what we say, my Lord, the board does not necessarily have to go that far. What we are saying is that reinforces and underscores the need for clear and precise and specific language to be used if you wanted to postpone the elections, take away the right to vote for an entire year, and extend the term of the incumbents, because the constitutional right in Section 4E is directly implicated. And yes, we do say, as a long study, that yes, it is covered, it is given constitutional shelter and protection by 4E.
Yes, I understand. Thank you.
Thank you very much, Mr. Ramlogan. Mr. Carter.
My Lords, can I just pick up before I start on a little bit of history and expand on a couple of points that my learned friend mentioned, without, of course, contradicting him. And the first, if I can take them in reversed order, is the case of Mohan. And, of course, Mohan concerned the actual wording of Article 3 of the first optional protocol. And it was precisely on the wording of that which linked it to national elections rather than elections generally. And of course the court found that there is no right, either under the convention or at common law, there is no right to a general universal franchise. That there may be in a democracy, there must be provision for a right for voting. How that is prescribed is not going to be determined by the common law. It isn't automatic, it isn't self-evident. It has to be articulated and detailed by legislation. But the right to vote, that right is a right. How it's operated, how it's manifested, is subject to the minutiae of legislation. The second point, my Lord, is on Section 29.2 of the Interpretation Act. Can I just check, please? I know we've been referring to the electronic record. Are you content for me to refer to the record rather than the core bundle?
Yes, it's probably easiest, but we can.
I think it is.
I think we're all using our screens.
As long as you give us the electronic page number.
Well, that's what I propose to do. So page 554, please, which is section 29, subsection 2. Sorry, I'm great. Mr. Ramlogan's referred to 29.2 and pointed out the distinction between office holder and a person who's appointed. Now, this is a point made. I don't ask you to look at it now, but it's at page 409 of the Respondents' case, at their paragraph 7. They say that paragraph section 29.2 applies to councillors and aldermen. And our submission is it clearly doesn't, because it applies to those who have been in subsection 29, subsection 2a. All officers and persons acting under the old law shall continue to act as if appointed under the written law. And that applies to the officers of a corporation who are employed by the corporation, not to councillors or aldermen who are elected. And we find that in the Municipal Corporations Act. If we turn please to page 698. That's the start of the Act. There's a definition here at 698 Corporate office means the offices of mayor or chairman, deputy mayor or vice chairman, alderman or councillor of a corporation. So those are that is the office. Going over the page to the next page. Corporation means a body corporate constituted by the mayor, alderman, councillors, and importantly, and electors. So the electors who vote in the councillors are part of the corporation. And the Municipal Corporations Act, therefore, regards the electors as an implicit part of the democratic institution of local government. And I submit that that's an important aspect in deciding whether, when the government decides, or rather when a government minister decides how to interpret and apply a statutory provision, whether he is actually doing something that disavows the rights of the electors and their place within that local institution. Going down a bit further to the next page, 700, the distinction between an elected officer and an officer in relation to a corporation at page 700. The definition within the Municipal Corporations Act of an officer means in relation to a corporation, the chief officers of a corporation mentioned in section 36, so not the elected people, and B, any other person appointed to hold or to act in a pensionable office in the service of a corporation and whose remuneration is paid on a monthly basis. In other words, echoing the wording of section 29(2) of the Interpretation Act, a person appointed or acting. And therefore, the respondent's submission about section 29(2) and how that applies to the amendment to this Act is entirely inapposite. Now, a bit of history. And the reason why I've included in the supplemental bundle some material about Anglo-Saxon England is simply to demonstrate. If this was a US brief, I suppose it would be the subject of a very protracted footnote, but I'm going to keep it brief. What it demonstrates is that historically, and bearing in mind that Trinidad and Tobago is a democratic constitutional state, did on independence adopt some of the features, the Westminster model to some extent, of the English constitution. And what it recognises is that historically, local government was far more important than national government. In fact, local government, preceded by about 250 years before the Magna Carta, the declaration that the king would summon various people to an assembly in order to pass taxation, and as it happened in due course, to become the legislature of the state. So when the respondents in their case say that, well, Parliament could do anything because local government elections really do not matter, they don't feature in the constitutional constellation, we have to look at what it means when a state like Trinidad and Tobago uses the language which has come down through history, from that history of local authorities having considerable importance as a democratic institution. And so we don't need to go into the details of what was meant by 100 and a wapentake. It's a matter of intellectual interest. But what it does demonstrate is that, as in Trinidad and Tobago, so for a long time in England, local authorities constituted the means by which effective democratic government was delivered by the government to the people of a democratic state, and even a pre-democratic state. We have to remember that in the Constitution talks about the nation of Trinidad and Tobago, the starting point, the nation of Trinidad and Tobago. The nation of Trinidad and Tobago came into existence with independence. It didn't exist as a nation until independence. When it gained independence, it was then eligible to join the United Nations. So when the Constitution starts off with the preamble, and we look at the fundamental rights, what Trinidad is doing is saying, we, the people of Trinidad and Tobago, we, the nation of Trinidad and Tobago, are a constitutional state. And what they're saying is that we have decided, as a constitutional independent state, to adopt the hallmarks of a particular kind of democratic state, because there are several. And the one we adopt, and we use the language which is entirely appropriate to that, is the language which we've inherited from England. And we do, as in from 1965, we adopted, for example, the term alderman, which has historic resonance. I doubt if that features anywhere in other democratic states. So what Trinidad and Tobago was doing in the Municipal Corporations Act, in setting out what the local authorities did, what their function was, is they're recognising through the use of their language, tied to the Constitution, as my learned friend has said, and with Section 4, the right to political expression through the ballot box. What the Constitution has done and what the Municipal Corporations Act has done, I submit, is to link the local authority fairly and squarely within that realm of the important democratic institutions which are preserved and protected, and over which Parliament must tread carefully. It can tread, but it must tread carefully, clearly, and explicitly if it is to do anything which interferes with the right of the electorate, who are part of the corporation, to exercise control over the corporation which they have elected on one basis, not the basis that the respondent now claim.
Mr. Carter, since you're helping us with the history, at the time when Trinidad and Tobago became a nation, did it already have aldermen?
No.
They were new?
They were new.
Uh-huh.
In fact, the Court of Appeal sets out the history.
I don't want to take you out of it, of course I know you're under time pressure, but
yes,
if you just give me the reference, I can
yes.
follow it up.
It's page 310
Of the main bundle?
of the electronic bundle, my lord, yeah. It's paragraph 41.
Yeah.
And aldermen seem to have come into existence in 1967 as part of the constitutional democratic landscape.
1967?
That's what the Court of Appeal say. Councillors existed long before that, of course. But the office of alderman, and your lordships will probably have picked up that...
Introduced, yes.
That councillors are directly elected. This is sections 11 to 13 of the Representation of the People Act. Councillors are directly elected by the local electorate, the franchise. Aldermen are elected by the political parties.
Yes.
And the number of aldermen each political party is allowed to elect is dependent upon the number of councillors belonging to that party who are elected. So it means that the electors of the local council directly elect councillors and indirectly elect aldermen. So both of those officers, both sets of officers, are subject to the democratic franchise, democratic mandate. Can I deal very briefly before, I can't remember what time I stopped, but it's probably about 5 minutes away.
Yes, I'm afraid it is 5 minutes away.
Yes.
If you want to go on longer, you can always eat into your reply time.
I deal with the proposition that Parliament could abolish local government in its entirety. That's what the respondents say at page 414, their paragraph 22. And this comes into what you might call the Dicey paradox. You will probably remember that Dicey, in his hypothesis that Parliament has absolute authority to do what it wants, found himself in a dilemma when faced with the proposition, can Parliament abolish itself? And so far as I recall, he never came up with a satisfactory answer to that. And that's a conundrum which it continues to exist. So, theoretically, hypothetically, Parliament could pass a statute which abolished local municipal councils. The respondents will no doubt say, well, it has a Municipal Corporations Act, it has created the formation of them, described what their powers are, how people are elected to them, therefore it could take all that away. Well, maybe it could, subject to Section 4 of the Constitution. But if it is going to do that, even if the board were to find that the municipal elections and the right to vote in municipal elections is not an embedded constitutional right, even if you were to find that, I would submit that if Parliament were to do that, it would have to think very, very carefully before it did so, before it denied the local populace an entire tier of a constitutional democratic process. And by way of an example, can we turn to the the Municipal Corporations Act at page 685, page 803. Under the Municipal Corporations Act, section 269, at the moment, it's right to say that local authorities are subsidiary to the national parliament or the national government, because the minister can give general or specific directions to any council which the council is expected to enforce. But if we move on to section 271, we see what happens if a council becomes a rogue council. That's not a term used in the Act. Section 271, subject to subsections 2 and 3, this is page 803. On receipt of an address from the House of Representatives on a petition signed by not less than 1/2 in number of the electors in the lists of electors for the electoral area of a corporation, the President may, by an order published in the Gazette, dissolve the council. An order for the dissolution of a council shall not be valid unless in and by such order a time is fixed for the election of a new council under the provisions of this Act in lieu of the council so dissolved, not more than 2 years from the date of such order. This is not prerogative. This is not something which Parliament can do at a whim. This is not something which Parliament can do without express thought, express provision. If the respondent's case is really that local authorities are so subservient, so unimportant, that Parliament could do away with them at a whim, then that argument is simply unsustainable. This demonstrates how embedded, whether constitutionally embedded or not, but embedded as a right, local elections are, and the right to vote for local elections are, within the democratic system which is constitutionally embedded in Trinidad and Tobago. So unless I can assist you further, I think my time is up.
Thank you very much, Mr. Carter. Yes, Mr. Rowe.
Thank you. Well, I propose, if I may broadly follow the scheme of our written case, which the audience can find at page 406. It's important at the outset in our submission to emphasise that the question that the board is asked to resolve in this appeal is essentially a question of construction. My learned friend accepted in answer to questions from your lordship and in the course of his submissions that It's not a case where there is any quarrel with the decision to exercise the power to proclaim the relevant sections, in other words, to bring them into force in pursuance of the power under the Statute Act, either in isolation or on the particular date on which they were brought into effect. And that's recorded, just for your Lordship's reference, in the Court of Appeal, in the judgment of Justice of Appeal Musai, who says this at page 332 in the record, paragraph 98. There has been no challenge to Parliament's right to amend the MCA in the manner that it did. The only challenge was to whom it was intended to apply, and there has been no challenge lodged with respect to the Cabinet's right to submit for proclamation the amended legislation on the date that they did. So we are concerned with the point of construction, and as my learned friend put it, there is no quarrel with the decision to proclaim. The question is Parliament, the Act having been proclaimed, or those provisions of the amending Act having been proclaimed, how stands the law of Trinidad and Tobago as regards the term of office for incumbent councillors? And as your Lordships know, our submission is a straightforward one, that on that date the term of office for incumbent councillors changed from 3 years to 4, with the consequence that the requirement under the Act for an election to take place was put back by a year. Our learned friend's case, as your Lordships have heard, is that that was all true as regards people to be elected at any future election. I'll come back to precisely what that means, because in fact that's problematic in itself, identifying what exactly you mean by people elected at a future election. But that as regards those who are incumbent councillors, they continue in office only as long as they would have continued if nothing had happened under the law, in other words, for 3 years. So that's the battleground between us. My Lord, it's helpful perhaps just to visualise the effect of the coming into operation of the amending Act, and we've sought to do that on page 408 in our case by adopting the lawyer's technique of crossing out that which is deleted and underlining that which is new. And the long and short of it in our submission is simply this, that if you looked at the Municipal Corporations Act, section 11, thereof, on the day before the amending Act came into operation, what you would see is the text there without the bits underlined and without the crossings out. The term of office of councillors, subsection 4 of section 11, shall be 3 years, and they shall retire together on the last day of every triennial period, the first of which shall be deemed to have begun on the day on which the councillors were elected to office. And 4A, an election referred to in subsection 1 shall be held within 3 months of the expiry of the term of office of the mayor, councillors and aldermen comprising the council. So it's an entirely self-contained code, and the same applies as regards aldermen in section 12. I'm not sure, incidentally, it's entirely right from the learned friend to say that aldermen were introduced into Trinidad and Tobago in 1967. We found a reference in 1922 in one of the pre-independence ordinances to the existence of aldermen, but that doesn't matter in our respectful submission to the determination of this appeal. And so you can see in section 12 the drafting technique is not identical, but it comes to the same thing. Previously it said aldermen will serve for 3 years, and now it says something different. And we see, going back to the something different in section 11, you can see that what Parliament has done is to change the answer to the question, how long do councillors serve in office? So if you looked at the section on the day that the Act came into operation, the amending Act came into operation, you see the new text. So the answer to the question becomes it's 4 years.
Can we do the same exercise as on the day when the Act originally came into operation, to see whether shall only apply to future or present officers?
When your Lordship says when the Act originally came into operation,
in its unamended, in its when the structure of section 11 using shall all the way through,
yes,
first came in.
Yes.
It would help me at any rate to understand how that would have applied to officers at that time. Would it apply to existing officers or to officers appointed at the next election?
Oh,
It may shed some light on the meaning of shall.
I see your lordship's
Because
point.
as someone previously involved in the drafting of procedure rules, I'm conscious that shall can be quite shark-infested water.
Absolutely. Well, shall is, yes. I mean, I think in relation to your lordship's question, can I, because I think that requires a fairly close look at the state of the law when the 1990 Act came into effect.
I appreciate
exactly how it did. So may I postpone answering that and
I'm only asking it now, so you've got a chance to
after the short adjournment, or failing that in a note afterwards.
Yeah.
Because, as you say, these are shark-infested waters, and I don't want to plunge in unprepared. But since your lordship mentioned this terminology, shall be, of course, it's true to say that shall can be used in the future tense. I shall be going to Spain on holiday next year. But of course, it's also an imperative in the present tense. You shall sit down now. You shall not come in here. And when it's used in drafting terms, it's generally not indicative of some future event. It's what the judge looks at when it says. To take an example that's been before the board recently, when it says the court shall give such judgment as the claimant appears to be entitled on the statement of claim. That's not talking about some future event. It's talking about what the judge, hearing an application for a judgment, is to do. Shall give such judgment as the claimant appears to be entitled on the statement of claim. So I would respectfully say that there's no particular significance to be derived from the word shall. The straightforward reading of Section 11 when it came into effect, or at any rate, as it was in effect before the amendment that we're concerned with, I'll come back to if there's any difference when it first came into effect, is that if you ask, well, how long does a councillor serve for and when is the next election, the answer is the councillor serves for 3 years from the last election, and the next election has to happen within 3 months of the expiry of that 3-year term. If you ask the question, once the Act is in force, the answer is exactly the same, except the figure is 4. And in our respectful estimation, that really is all there is to it. And there is really no ambiguity whatsoever in the terminology of the statute as amended, or perhaps more pertinently, there's no ambiguity in the amending Act. Because ultimately the contest before the board is as to the effect of the amending Act. What did Parliament intend by those sections of the amending Act that say that the word 3 is to be replaced by the word 4? And we've set out in our case, just for ease of reference, with a lot of irrelevant stuff deleted, what the amending Act says. This is page 406. Shall come into operation on such date as is fixed by the President by proclamation. I suppose another aside in the context of tenses, it says as is fixed rather than as will be fixed, but that's perhaps because everyone can understand what it's saying. Municipal Corporations Act is amended in Section 11, in subsection 4, by deleting the word 3 and substituting the word 4, and deleting the word triennial and substituting the word quadrennial. And the same for Alderman in Section 12, except it's done compendiously rather than by singling out just the words 3 and 4 and triennial and quadrennial. And we do place some emphasis on the fact that the amending Act, first of all, says that it shall come into operation on the day that's fixed by the President by proclamation, and secondly, that it simply says the Municipal Corporations Act is amended. It doesn't say is amended, but not in relation to existing incumbent councillors and aldermen, or is amended with effect from the date of the next election, or with effect, and that would, as I'll come on to argue, that would need to be more precisely spelled out, not just the date of the next election, but which particular part of the electoral process. It doesn't say that; it just says is amended. And so, in our submission, that really supplies the answer to the question of construction that arises in this case. And really, what's then left is simply, is there any reason in the face of that for the board to construe the Act in some other way, based upon the various other contextual and constitutional arguments that are put forward? We rely, and we set it out at paragraph 7 of our written case, we do rely on section 29 of the Interpretation Act. But I wouldn't want to be misunderstood as thinking that, as suggesting that that's essential to our case. I mean, it's consistent with our case, and it plainly operates to supply any difficulty, or to supply an answer to any difficulty that might be said to be by virtue of people having been elected under one rule and now serving under another. We take the point, of course, it says appointed there rather than elected, but in our respectful submission, that use of terminology doesn't mean that it has no application.
You say appointed includes elected.
Appointed can include elected.
Yeah.
An election is a form of appointment.
Yeah.
But as I say, we don't place everything. We don't place all our bets on that section. That it simply tends, we suggest, to support our interpretation. Our learned friends say, well, yes, but look, Parliament didn't make express provision about what should happen for incumbent councillors. And of course, it's true that Parliament could have done that. And our learned friends are able to point to some instances in the past where Parliament did make express provision about what would happen to incumbent councillors. But it doesn't follow from the failure to do it on this occasion that you make the statute mean anything other than that which, in our respectful submission, you make it mean anything other than that which, in our respectful submission, it plainly means. One can always find cases where Parliament could have made its meaning clearer than it did. But that is not by itself necessarily a powerful reason for saying that the meaning is somehow different. We refer to the change to the years of ordinary elections Wales order simply because, as we emphasise in the passage we've quoted from it at paragraph 10 of our case, it's recognised there by the draftsman that the very effect of changing the dates is to extend the term of the relevant councillors. The term of office of existing councillors is accordingly extended by 1 year. And we respectfully submit that's essentially a redundant provision. But what's important for present purposes is it recognises that is simply the effect of changing the dates. And there's no point of distinction that we respectfully submit, contrary to what my learned friend Mr. Rambogan argued. There's no point of distinction between the setup in Wales and the setup in Trinidad and Tobago as far as this point is concerned. It's true that, as you were shown, there are slightly different arrangements as to when the term of office of a councillor comes to an end in the system set up under the UK, or at any rate England and Wales Local Government Act. It comes to an end 4 days after the election. But the important point is that in the Trinidad and Tobago legislation, as we've seen, the coming to an end of the term of office is spelled out expressly, and the date when the election has to be held is linked directly to that term of office. So there is no way out in our submission of the conclusion that when Parliament says, well, the term of office has changed from 3 to 4 years, it is putting the election back. It doesn't need to say so expressly, because it's done it by necessary implication, because well, not by implication, but it's done it because the election is expressly linked to the term of office. So, for that reason, we suggest that the Welsh example is instructive, but we won't put very hard on that. The case is put on our learned friend's side as being, well, it must be, and you should read this as not applying to current councillors, but applying to those elected at the next election. My learned friend didn't really address this point, but we deal with it in our printed case. It's not, in fact, we submit as simple as that, because, and we've set this out at page 441, paragraph 13 of our case. In short, an election is not an event; it's a process. And we've set out the relevant provisions. The Act, the Municipal Corporations Act, that is to say, says that the councillors are to be elected as provided for in the Representation of the People Act. That takes you to that Act, and I don't think I need to take you to the text itself, unless you'd like me to particularly, but we've summarised it, I hope, fairly there. You have to institute a writ of the election by issuing a writ of election. That has to specify the date of nomination of the candidates, which has to be not nearer than 14 days away, and the date of the poll, which has to be not nearer than 21 days away. And then candidates are nominated and then the poll is carried out. And that being so, one can see in our respectful submission that it's not enough actually to say, well, Parliament must have intended this to take effect for future councillors. In our submission, and this is a little bit like, you might think a little bit like implying terms in a contract. If you're going to say that something needs to be implied into this scheme, because that essentially, in our submission, is what the appellant is saying. You've got to be clear about what it is that's to be implied into the scheme. It's not enough to say, well, it's obvious the implication is that this all happens at the next election. Current councillors don't have their terms. You've got to say what you mean by at the next election. Do you mean at the moment at which the election is called? Do you mean at the moment at which the nominations have closed and are in? On the logic that is applied by our learned friends in the context of their points about the unfairness to individual councillors, it might be thought that it's after the critical days when nominations go in, because until nominations go in, the person who is thinking about putting himself or herself forward to be a local councillor or alderman is working on the assumption that that's a 3-year commitment, and then it changes to 4 years. So, but the reason I've raised these points is simply to illustrate that in our submission, it's what's in effect a proposed implication into the plain text of the statute fails the test of clarity that there ought to be if one is to imply text into any instrument. In other words, one needs to, when I say clarity, one needs to be clear what text it is that must be implied. If you could possibly imply more than one thing into the text, then the fact that one might be more or less sensible than another is not by itself a good reason for saying it's implied.
That's not a problem in this case, is it? Because if the amendments are construed as not applying to incumbent councillors, they came into effect for the purposes of the next election before there was any writ for the next election. So the problems you're posing in paragraph 13 don't actually arise in this case, on the appellant's case.
Well,
in other words, in choosing that date for making the proclamation, it could be said that the government had given thought to the very points you're raising.
Well, this comes back, my Lord, to my opening observation that this is a question of construction.
Indeed.
If the question of construction can't depend upon the date upon which the government decides to bring the Act in. Or I
it might be assumed that the government would act sensibly.
Well, my Lord, it might, but that's not that doesn't answer the question as to what the Act means.
Surely Acts of Parliament should be construed on the basis that the government will act rationally.
Rationally, I'd perhaps be more pointed to see. Sensibly, I'm not so sure, because that's...
Well, you might be saying that it would be irrational to bring these provisions in when it would cause the sort of confusion you say would arise. Well, assuming you're right about that, the answer is for the government to behave rationally as it would when it brings in the provisions.
Well, my Lord, that's an answer. Whether that's an answer depends on where you start. If you're trying to answer the question, what does the text of the Act mean? What's Parliament's intention?
Yes.
Then you're faced in the present case between we would respectfully submit a straightforward answer. Well, it means what it says. Is essentially what
irrespective of its context.
Irrespective of the date.
Irrespective of its context.
Well, no, in its context as well, we say, but its wording is clear, and I'll come on to deal with some of the other elements of context that my friend touched on. But if on the other hand you say, well, I'm considering a construction that actually means it doesn't apply to incumbent officers, office holders, elected office holders, then you've got to deal with the objection I've just raised about, well, hang on, how does it work if it's brought into force on such and such a date or such and such a date? If you find yourself having to deal with that by saying, well, Parliament must have assumed that the government would act rationally in deciding when to bring it into force, your alarm bells ought immediately to be ringing in my respectful submission as to whether that's actually a tenable construction, one that depends upon future determination as to whether the government has or hasn't acted rationally in bringing it to force. I mean, in other words, Parliament could have said in this Act that the power to bring acts into force in pieces which exist in the Statute Act doesn't apply to this piece of legislation. It didn't say that, so it worked on the assumption that the Act could be brought into force piece by piece. And indeed, we respectfully submit there's nothing at all unusual or surprising about the notion that one discrete element of the package of reforms, the increase of the terms, could be brought into force separately. In fact, the whole Act, the amending Act could simply have said that, like the Welsh example. It could simply
say what? Sorry.
I'm sorry.
Sorry. It could have said what?
It could simply have said that the Act comes into that the term is extended, and not have had all the other stuff about
yes.
other reorganisations. But my I think
why it didn't.
Well, it didn't because because Parliament presumably intended that at some stage further reforms could be brought into effect. But that doesn't mean. I mean, my friend didn't really emphasise this in his oral submissions, but there is I think, point that's made in his case about the fact that it's a package of measures. But I don't think he went as far as to say, actually, the Act, this provision altering the term couldn't be brought into force except as part of the overall package. And rightly so, because that's inconsistent with the existing power to bring into effect separate sections of an Act at different times.
Well, I hadn't thought about this until the matter's being discussed now, but I see if you look, for example, at the Municipal Corporations Act on page, wherever it begins.
685 is the beginning of the Act.
Here we are. At 698, you find section 1. And subsection 2, this Act shall come into operation on such date as the President may by proclamation appoint, and different days may be appointed for the purposes of different provisions of this Act. Contrast page 598, the Local Government Reform Act, section 2, this Act shall come into operation on such date as is fixed. This Act shall come into operation on such date, singular, as is fixed by the President by proclamation. So there's nothing there about different dates for different provisions.
No, well, that's right, but that is in the context of the Statute Act, which you can find at 951, right, which makes general provision for what the meaning is of a provision like the one that you just read out. Oh. 5.2 of the Statute Act.
Yep. I see. Yes, that's the answer to my point. Thank you.
But sorry, just to go back to section 11.4.
Yes.
Is there any reason in terms of machinery why the amendment could not be brought into effect on the date that it was, but only in relation to future elections, which I understand is the submission which is made against you?
Is there any reason why it couldn't have been?
Is there any reason why it shouldn't be understood as applying only to future elections, having come into force on the date that it did in its amended form?
Well, yes, my Lord, the reason is that requires you to read words in that Parliament didn't put there, in our respectful submission. If one wants to know what the law is, one looks at what the Act, the relevant Act says. And our simple point is if you carry out that exercise at a time when the amending Act is not in force, you go to the parliamentary roll, as it were, and you look at section 11 and you ask yourself, what is the term of office of councillors? The answer is 3 years. A few days later you go and look again and you find the answer is the term is 4 years. And it's, in our respect to this mission, it really is as straightforward as that. All right, notice the time.
On that
Maybe
straightforward point.
Shall I resume at 2 o'clock?
Very well. We'll adjourn now and resume at 2 o'clock.